Good morning, ladies and gentlemen. We'll start day 2 of this jurisdictional hearing. Before we turn to the first witness, are there any housekeeping matters which we need to address? We ask the respondents first.
Yes, Mr. President, there are two issues I would like to address briefly. The first is that El Salvador waives the confidentiality of all of the exhibits to Mr. Parada's witness statements, so they can be brought up on the screen today, and the tribunal may refer to them and quote from them in its decision.
Thank you very much. And the second?
And the second is we would like to ask the tribunal's indulgence if we could have an extra 10 minutes on the direct of Mr. Parada, so it would be 25 minutes rather than 15, and we would try, of course, to do it in less time than that.
If we can address the second matter first and ask the claimants if they have any comments on the application to extend time for direct examination from 10 to 25 minutes.
We would, of course, be willing to deduct that time from our direct, from our cross of Mr. Shrake.
Well, that's all fine and good, but we do object to Mr. Parada being given any additional time on direct. Everything that he has to testify on direct is already in his witness statement, and those were the rules of the game that were established by the tribunal. There's no reason why he should be allowed to testify for longer on direct, and certainly shouldn't be allowed to testify on anything that is not within the scope of his witness statement that's already been tendered.
Can we ask you to comment on that? Because what is it that he will add beyond the 10 minutes? If it's in his witness statement, it's there, he'll no doubt be cross-examined on it, he can be then re-examined by you. But if it's not in his witness statement, is it something new that we need to have advance notice of?
There is nothing new. It is simply that we feel for a proper introduction within the direct examination, we would require 25 minutes rather than 15.
Just give us 2 minutes. So I may have misspoken. I think the original time allowed was 15 minutes. No, I said 10 minutes, but we have decided to maintain it at 15 minutes. So we'll have 15 minutes direct examination and cross-examination, but then obviously there will be redirect examination arising from the cross-examination.
Thank you, Mr. President.
Any more housekeeping from the respondent?
Nothing further.
And from the claimants?
None from the claimant, just a request, Mr. Chairman. We are going to be doing closings either tomorrow afternoon or tomorrow morning. I haven't had an opportunity to discuss this with Mr. Smith, but it would be helpful if the tribunal could give us some direction at the end of today as to what are the issues that you would like us to address, so that we aren't really regurgitating everything that we have said in openings and in our extensive written submissions.
Well, we can certainly indicate that was our intention already. We'll hear the 2 witnesses and then we might take a short break, but then we would plan for the future, and we would include tonight questions that have arisen in our minds from your opening oral submissions from yesterday. So that's the plan, and we hope there'll be enough time to do that at the end of the oral evidence. And then we'd plan as to what exactly we need to do tomorrow. We need to check whether there are any oral submissions by the non-disputing parties which have to be slotted in either this evening or tomorrow morning. But perhaps we'll come to that after we hear the 2 witnesses, if that's convenient to both sides.
Indeed, from claimant's standpoint, that.
Yes, from
Thank you.
respondent as well.
Well, without any more, let's proceed to the first witness.
Mr. Chairman, Mr. Posner will be conducting the cross-examination from our side.
Good morning, Mr. Parada.
Good morning, Mr. Chairman.
You have before you a form of oath, and we'd like you to formally state your full name, followed by the words on the sheet of paper before you.
Yes, sir. I, Luis Alberto Parada, solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you very much.
Good morning, Mr. Parada.
Good morning.
Good morning, Mr. Parada.
Good morning.
Are you currently employed?
Yes.
And who is your employer?
Dewey and LaBeouf.
And you are representing El Salvador in this arbitration, correct?
Correct.
Now, and you have put in a witness statement in this arbitration that I believe you have before you as Annex 1, correct?
Correct.
Now, it seems to us, and I'm sure the tribunal shares this view, that it's quite extraordinary for a counsel for a party to also put in a witness statement.
Mr. Chairman, I don't wish to interrupt Mr. Badini's direct examination right when he's starting out, but on direct examination, I don't believe that leading questions are permitted, nor is testimony by counsel permitted. So I do think that there are some rules of the game that we ought to observe, and Mr. Badini knows those all too well.
I'll rephrase the question. Mr. Prado, what prompted you to put in a witness statement in this case?
I had personal knowledge directly from Mr. Ali and Mr. De Gramont that their law firm and they themselves were already working on this case before the change of nationality of Pakram Cayman. And so when they started denying that there was even a dispute that had crystallized in this arbitration before the change of nationality, and this was back in August, that's what prompted me to suggest that we do discovery requests on Pakram Cayman so that they would reveal that they had already been hired. They refused, and then later, when I saw in Mr. Schreck's witness statement that they even denied that they had any idea that there was a dispute before the change of nationality, which I knew that was not correct. And then I felt compelled to come forward with the knowledge that I had.
Mr. Prado, what is the nature of the personal knowledge that you acquired that led you to conclude that Mr. Schreck's witness statement was incorrect?
Back in October of 2007, I was contacted by a recruiter on behalf of Crowell & Mooring that invited me to consider transferring to work at the international arbitration practice of Crowell & Mooring. And I, in fact, had a series of interviews at the end of November of 2007, and among them I spoke with Mr. Ali and Mr. De Gramont, and they told me that they were already working on the case, that their client had been denied for a long time or had not been granted the concession that they was seeking in El Salvador, and that if client didn't get it, they would start arbitration under exit.
Let me put in front of you Annex S1 to your witness statement, and perhaps we can put it on the screen as well. I don't see it on the big screen. But while we're waiting, so we don't waste any time, can you identify what the Annex S1 is?
That is an entry in my personal agenda where I normally keep my schedule and my meetings, and it reflects that on November 27th, 2007, it has an entry that says 9:30 meeting.
And that's your handwriting?
Yes.
And who was this meeting with?
As to the best of my knowledge, I have placed that this is the meeting when I went to Crowell & Mooring and I met with Mr. Ali and Mr. De Gramont, among others.
And let me show you Annex A, which is also attached to your witness statement. Can you identify this for the record?
Yes, that is the email that I received from the legal recruiter following up a phone call that she made to my office in which she introduced the international arbitration practice of Crowell and Moring.
And did she attach anything to that email?
Yes, she had copied and pasted from, I believe, the Crowell and Moring website information about their practice overview and the biographies of the main attorneys in that practice.
Now, at this November 27, 2007 meeting, who did you meet with at Crowell and Moring?
I met with, I believe, 5 attorneys from Crowell and Moring, among them Mr. Ali and Mr. DeGramont.
And what did they tell you during that meeting?
Specifically, it was Mr. Ali who gave me more information. He said that they were, of course, he knew I was from El Salvador, and in our conversation, I'm sure they were aware of my many contacts with El Salvador. So he told me that they were working on a case, on a potential case, in which their client had not been granted mining permit, and that if they were not granted it, they would go to arbitration.
Did you have any subsequent meetings in or about this time with either Mr. Ali or Mr. DeGramont?
Yes.
When was that?
The following week, I received a call from Mr. DeGramont inviting me to a breakfast follow-up meeting with himself and Mr. Ali.
And let's put in front of you Annex S2 to your witness statement. Can you
Yes.
identify that document?
Yes, that is another entry in my personal agenda that reflects that in on December 7th, 2007 at 8:30 a.m. I have marked Les Alls pen and something.
So what does that entry indicate?
That is the Les Alls is a restaurant that used to be on Pennsylvania Avenue, and that's where the meeting took place.
And did you, in fact, have a breakfast meeting with Mr. DeGramont and Mr. Ali on that date?
Yes, I did.
What was said during that breakfast meeting?
Among other things, because they were trying to recruit me to go work for them. Of course, there were many things said, but of interest to this arbitration, Mr. Ali confirmed that they had been working on this case, and again, he said that if their client did not get the permits, they would initiate arbitration against El Salvador, and they were confident that they would win.
Now, to your knowledge, have either Mr. Ali or Mr. DeGramont ever denied meeting with you on that day?
To my knowledge, they have never denied meeting with me on that date or the other date.
Now, let's talk about the substance of what was said during that day. You were here yesterday, were you not, when Mr. Ali gave his preliminary remarks?
Yes.
Did you hear him make the following, ask the following rhetorical question to the tribunal? Quote, do they truly believe in good faith that the chair and vice chair of a leading international arbitration practice would have been so inexperienced as to have discussed a client's business and legal strategy with a potential associate candidate in the course of a screening interview? Did you hear Mr. Ali ask that question?
Yes, I did.
Did you hear him give an answer to that question?
No, he did not answer that question.
Has Mr. Ali or Mr. DeGramont did they have an opportunity to put in witness statements in this case to deny the accuracy of what you recounted as the conversations?
I don't think that's a question for this witness.
I'll withdraw the question, thank you. Putting aside the witness statement, to your knowledge, have they ever denied the substance of what you said they said to you at those two meetings?
To my knowledge, they have never denied it.
What, if anything, did you do in reaction to what you learned from them during those two meetings?
After some time had passed, and after I had informed Mr. DeGramont at a international arbitration conference in New York that we happened to attend, that I was not the person that they were looking for to hire. And after deciding that I had no duty of confidentiality regarding the information they had given me, and knowing that I was planning a trip to El Salvador to attend the special award, the highest award the country of El Salvador can give to anyone, to my former boss at the Embassy of El Salvador and at the Ministry of Foreign Affairs. Then I decided that it was time to take action. And then I contacted a friend at the Embassy of El Salvador, got the contact information for the Attorney General of El Salvador, and I made a phone call and then sent an email.
So let's show you Annex D to your witness statement and ask whether that was one of the communications you made with El Salvador.
Yes, that is the first email that I sent to the assistant, to the administrative assistant, to the Attorney General of El Salvador.
And this is dated March 7, 2008, correct?
Yes, correct.
And can you read the last sentence that's highlighted on the screen?
It says, the purpose of my meeting with the Attorney General is to offer the services our firm generally, and specifically to update the Attorney General on a possible international dispute in the making at this time that may result in an international exit arbitration against El Salvador.
And did you send any subsequent emails to El Salvador on this topic?
Yes, I did.
Let me show you Annex F to your witness statement and ask if this is another email that you sent on or about April 8th, 2008.
Yes, it is.
And can you read the highlighted sentence into the record, please?
Yes, this is a subsequent email I sent because we were not able to meet at that time. And I say, as I mentioned to you prior to Easter week, it would be a pleasure for my boss, Derek Smith, and me to meet with you briefly to introduce ourselves, offer you our services in any future matter related to international arbitration, and specifically to discuss an area in which an exit arbitration against the Republic of El Salvador might be initiated under the CAFTA framework.
Now, you reference a CAFTA framework as a potential arbitration. Do you see that?
Yes.
What was your source of information about the fact that a CAFTA arbitration was contemplated?
Because Mr. Ali told me that.
Did you have any other source for that information?
Absolutely not. At that time, knowledge that Crowell and Mooring and PACRIM, Cayman, and Pacific Rim Mining Corporation was planning any arbitration against El Salvador, much less under CAFTA, was not public knowledge.
And what was the date that they gave you that information that it would be a CAFTA arbitration?
They gave that information to me at the very latest on the second meeting we had on December 7th of 2007.
And now that you've been party, that you've been counsel in this arbitration, you know the date that the claimant became a U.S. national company, correct?
Correct.
And what is that date?
December 13th, 2007.
So your meeting with Mr. de Gramont at La Halle's restaurant was before or after that?
My meeting with Mr. Ali and Mr. de Gramont at La Salle restaurant was before the change of nationality.
Did there come a time when the arbitration became public, right?
Yes.
And let me show you Annex I to your witness statement. Did you draft this email?
Yes, I did. I drafted and sent it to the Attorney General.
And look at the first sentence which we've highlighted, and can you tell us what you intended to convey when you wrote that to the Attorney General?
Well, I had been, since that my first email to him on March 7th, trying to obtain a meeting with the Attorney General. I had not been able to get the meeting. So I was trying to convey to him that what the dispute and the potential arbitration that I had been wanting to talk to him about finally had resulted in a public threat of arbitration against El Salvador.
Did you also have internal communications with partners of the Dewey and LaBeouf firm about the arbitration when it became public?
Yes, I did.
Let me show you Annex R to your witness statement. And can you tell me what this is?
Well, actually, that's one of the latest emails that I sent, and that was on December 2008. And that was when not only the arbitration had been public since July, but also after the claimant filed the notice of intent. In that one, I'm responding to an earlier email from Mr. Eric Schwartz, who was co-chair of the Dewey and LaBeouf International Arbitration Practice, noting the filing of the notice of intent. And I'm saying, we have been on top of that dispute since last December, when I first learned that opposing counsel was preparing for arbitration.
Now, during the time of all of these communications, namely your meeting with Messrs. Ali and de Gramont, your follow-up communications with the government of El Salvador, did you have any reason to believe in that time period, in December of '07 through the beginning of '08, that the claimant would take the position here in this arbitration that the dispute did not arise until after President Saka's statement in March of 2008?
No, at that time, I did not have that knowledge.
Your witness.
Thank you.
Thank you.
Good morning, Mr. Prada. I want to start by asking you about the two interviews you had with Mr. Ali and Mr. de Gramont. Those two meetings occurred only 10 days apart, correct?
Yes.
Isn't it the case that those meetings happened in such close proximity because Mr. Ali was in fact not able to meet with you at the first interview on November 27th?
No, it's not.
So Mr. Ali was indeed present at the November 27th interview?
I believe so.
And you were interviewing for an associate position, correct?
I don't know what I was interviewing for, because the actual person who got hired was hired as counsel.
When the legal recruiter approached you about doing this interview, did she indicate what position you would be considered for?
I don't think so.
Did you have reason to believe you were being considered for something more senior than an associate position?
No,
So you believed you were being considered for an associate position, correct?
I did not know.
You had no belief about that one way or the other.
Correct.
And it's correct, isn't it, that that meeting on November 27th was in effect a screening interview?
Correct.
So you had never met Mr. Ali previously, correct?
Correct.
And you'd never met Mr. de Gramont previously, had you?
Correct.
And you said in your direct testimony that you met other lawyers at the firm, correct?
Yes.
Who were the other lawyers you met?
I do not remember the names exactly. I just remember one of them was Baiju Vasani. And then I met with who I believe was the co-chair of the practice, and then I met with a female senior associate.
And when you met with Mr. de Gramont and Mr. Ali, did you meet with them together or separately?
Separately.
And when you met with Mr. Ali, was there any other lawyer present, or was Mr. Ali alone?
He would have been alone.
And when you met with Mr. de Gramont, was he with another attorney, or was he alone?
Alone.
And did you understand at the time that Mr. Ali was the chair of Kroll and Maureen's international arbitration practice?
Yes.
Did you understand that Mr. de Gramont was the vice chair of that practice?
No.
Did you understand that each lawyer was had over 15 years of experience practicing law when you met with them?
I don't believe so.
Had you read the biographies of them that the recruiter sent to you before showing up at the meeting?
I had looked at them.
So you were aware of the contents of those biographies, correct?
Yes.
So just so I'm clear on this, Mr. Prada, it's your contention that in the course of a screening interview, these two senior partners at Kroll and Maureen each separately revealed to you their plan to start ICSID arbitration against El Salvador. Is that correct?
I believe so. I'm not sure if Mr. de Gramont went into as much detail as Mr. Ali.
But in any event, each of them, independently of the other, revealed this client confidential information to you, correct?
Objection.
On what grounds?
Characterization of the information. You're testifying.
I don't believe that's correct. I'm just trying to confirm it. Oh.
Microphone problem. Yes. Whether that's right or wrong, you might want to say out the question into two parts,
Okay.
dealing with each particular person.
Okay, so just so we're clear on this, Mr. Prada, Mr. Ali revealed to you the information about his plans to initiate arbitration against El Salvador that you describe in your witness statement, correct?
Correct.
And Mr. de Gramont, separately from Mr. Ali, also revealed that information to you, correct?
It may have been that I mentioned to him what I had been told, and he confirmed it, but yes.
And you're certain that you learned this information at that first meeting on November 27th, correct?
I believe so.
Even though in your direct testimony a moment ago you said that you learned this information at the latest at the second meeting, correct?
Correct.
Now, in your meetings with Mr. de Gramont and Mr. Ali, did you discuss your professional background?
Yes.
Did you tell them that you had spent 15 years of your career working for the government of El Salvador?
Yes.
Did you tell them that you had been a paratrooper in El Salvador?
Yes.
Did you tell them that you had worked at El Salvador's embassy to the United States?
Yes.
And in fact, you'd spent 4 years there, correct?
Yes.
Did you tell them that you had been Secretary General to the Ministry of Foreign Affairs?
I believe so. Yes.
Did you talk about your career as a lawyer?
Yes.
And by the way, Mr. Parada, regarding your career as a lawyer, if I understand correctly, you got your JD degree from Georgetown Law Center in 2001, is that right?
Correct.
And when were you admitted to the bar?
2001.
Also in 2001. Now, your first job out of law school was at the law firm of Arnold & Porter, correct?
Correct.
Did you discuss your work at Arnold & Porter with Mr. Ali and Mr. de Gramont?
Yes.
And one of the matters you worked on when you were at Arnold & Porter was a case known as Incesa Valle-Sultani versus El Salvador, correct?
Not pronounced that way.
Okay,
but
I apologize for the pronunciation,
But
but
the
you know the
Incesa
case I'm
case.
referring to.
Yes.
I'll refer to it as the Incesa case, okay?
Yes.
And you represented the government of El Salvador in that case, correct?
Correct.
Did you discuss your work on the Incesa case with Mr. Ali and Mr. de Gramont?
Yes.
And the Incesa case was initiated around July 2003, correct?
Yes.
So you were just about 2 years out of law school when that case got started, right?
Right.
Now, I'd like to go back to Annex D to your witness statement, which Mr. Badini had on the screen, and we've posted our own copy of it up there on the screen. So, as I believe you testified earlier, this is your March 7th, 2008 email to an assistant to El Salvador's Attorney General, correct?
Yes.
And in this email, you say that you, and I'm quoting, had the privilege of being an active participant in our selection, meaning Arnold & Porter's selection, as the attorneys for the Attorney General's office in the Incesa case, correct?
Yes, that is correct.
In your meeting with Mr. Ali, in your meetings, the November 27th and December 7th meetings with Mr. Ali and Mr. de Gramont, did you discuss your role as an active participant in Arnold & Porter's selection as the attorneys in Incesa?
I believe I may have.
And do you know or you believe?
I believe.
In that same email, a little bit further down, you state that you were, and again I quote, honored to have conceived and proposed the legal argument that eventually resulted in an important victory for El Salvador in the Incesa case. Do you see that statement?
Yes, that's correct.
That's pretty impressive to have come up with the winning argument only 2 years out of law school, isn't it?
Not really. I actually came up with a winning argument on another case while I was still in law school.
So not terribly impressive then.
I don't think so.
Okay. In your meetings with Mr. Ali and Mr. de Gramont, did you discuss your role in conceiving and proposing the legal argument that resulted in an important victory for El Salvador in Incesa?
I believe so because I discussed that I felt so strongly about that theory of the case that it actually led to my departure from Arnold & Porter.
I see. So that's what prompted your departure from Arnold & Porter was your theory of the case in Incesa?
Not my theory of the case, but the resistance from the senior partner, Arnold & Porter, to continue with that legal theory.
I see. And you told Mr. Ali and Mr. de Gramont about this in the course of your meetings with them?
I believe so. I told them reason why I departed from Arnold & Porter.
And when did you depart from Arnold & Porter?
In August of 2004.
And that was just when that case was getting started, right?
It was after the first session of the tribunal.
But it was before objections to jurisdiction were filed, right?
Correct.
And so having been an active participant in Arnold and Porter's selection and having conceived and proposed what would become the winning argument, you left just as the Encesa case was getting off the ground, correct?
Correct.
And by the way, following your departure from Arnold and Porter, have you ever formally approached that firm for purposes of possible reemployment?
Yes.
And when you left Arnold and Porter, you went to the firm of LeBoeuf, correct?
Correct.
And that firm subsequently merged with Dewey Ballantyne and is now Dewey LeBoeuf, right?
Correct.
And that's where you're currently employed.
Yes.
Now, was there any other work for the government of El Salvador that you discussed in the course of your meetings with Mr. de Gramont and Mr. Ali? Sorry? Oh, okay. Was there any other work for the government of El Salvador that you discussed in the course of your meetings with Mr. de Gramont and Mr. Ali?
Yes, I am very sure that I talked about my previous work for the government of El Salvador, as we had mentioned before, being a member of the Army of El Salvador and having been assigned as a diplomat in the Embassy of El Salvador in Washington, D.C. for 4 years, and having been the Secretary General of the Ministry of Foreign Affairs of El Salvador, which is the third highest position in the ministry.
Did you discuss any other legal work that you'd done on behalf of the government of El Salvador?
I do not believe so.
Now, I want to turn now to your witness statement, Mr. Prada, and in particular to paragraph 6 of your witness statement. If we can put that up on the screen and maybe expand that, that's good. So in your statement, you say that at your first meeting, the one in November of 2007, and again, I'm going to quote here, Mr. Ali and Mr. de Gramont explained that they were trying to resolve a mining dispute in El Salvador, and that if El Salvador did not grant the concession, they would start ICSID arbitration against El Salvador. You see that?
Yes.
Now, in your recollection, Mr. Prada, did Mr. Ali and Mr. de Gramont explain this to you before or after you told them about your past work on behalf of the government of El Salvador?
I do not know.
So you don't know whether this statement occurred before they'd gone through your professional history?
I don't know, but again, my previous employment with the government of El Salvador was available on my bio in my website and on the website of our law firm, so the fact that I had worked for 15 years for the government of El Salvador would not have been unknown to them.
Mr. Prada, in your experience, would it be normal for lawyers conducting a screening interview to tell you about the projects that they were working on before they'd ask you a few questions about yourself and your own professional background?
Objection, foundation, and hypothetical.
I don't mind to answer that question.
Mr. Chairman, it just goes... Oh.
You do, otherwise you veto all of us. It's one way of keeping us quiet. I think there ought to be some latitude in the way the question is put, but again, if you can rephrase it, I suspect this question you could rephrase.
Okay, I just, in terms of Mr. Badini's objection with respect to foundation, I believe the witness has already laid the foundation by stating that he couldn't recall whether this client confidential information was revealed to him before or after he talked about his own professional background. And I'm simply asking him, in his own experience, what would be ordinary in the course of a screening interview where the partners had never met the person at all.
How many screening interviews have you done?
I may have done 5, but I have also conducted interviews myself in which I may have talked about cases I'm working on.
Well, if you can answer the question, please
Yes.
try to do so.
I would say, Mr. Postner, that it depends on what the purpose of the person conducting the screening is. And I asked myself that question at the time, why are they telling me this? And I concluded that perhaps, knowing my relationship with El Salvador, they were wanting me to relay that information to El Salvador so that El Salvador would know that there is an international arbitration law firm already preparing an exit case against them, and therefore they would try to avoid going to arbitration and give in to whatever the company wanted. That was my conclusion.
And it's your contention, Mr. Prada, that they may well have revealed this information to you before you even told them about your own professional experience?
I don't know. I don't recall.
And you said you drew this conclusion in your own mind as to why they were telling you this information. Did you ask them why they were telling you this information?
No, this was thoughts I had after these conversations.
Did you say anything in response to this information that was being revealed to you by Mr. Ali and Mr. de Grammont each independently?
I believe I just acknowledged it.
Did Mr. de Grammont or Mr. Ali tell you the identity of the claimant in the ICSID arbitration they allegedly intended to start?
No,
Did you ask?
no.
Isn't it true, Mr. Prada, that a company called Commerce Group brought a CAFTA claim against El Salvador related to a mining investment in July 2009?
Yes,
In fact, you represented the government of El Salvador in that arbitration, correct?
correct.
Did you know that the ICSID arbitration that Mr. de Grammont and Mr. Ali allegedly intended to start was not on behalf of Commerce Group?
Objection. No, the counsel is testifying.
It's simply a question. I asked him what he knew, and I believe he just answered the question. And I'm prepared to move on. Right.
I'm sorry, I'll re-say what I was going to say. We'll leave the question and the answer as it is. Please proceed.
Did Mr. de Grammont or Mr. Ali tell you the amount of damages they intended to seek in this arbitration?
No,
Did you ask?
no,
Did Mr. de Grammont or Mr. Ali tell you the timing of the ICSID arbitration they intended to start?
no,
Did you ask?
no,
Did either of them tell you that the arbitration they intended to start would be under CAFTA?
yes.
Although you don't say that in your witness statement, do you?
I believe, I believe I do.
Is that in that paragraph 6? I don't see it. Maybe you can point me to where you say that.
Paragraph
Mr.
7.
I see, in paragraph 7, okay. And did they tell you it would also be started under El Salvador's investment law?
No,
Now, in paragraph 6 of your statement, in the sentence that follows the one we focused on a moment ago, you say, and I quote, "I was aware of the issue through the Salvadoran press." What do you mean by the issue?
I'd read the Salvadoran newspapers online almost every day. I was aware that there was a mining dispute in the brewing. I was aware that the company was Canadian. I assumed that was the case they were talking about.
On what basis did you assume that was the case they were talking about?
That was the only case that came to my mind at the time.
Did you say to either Mr. Ali or Mr. de Grammont, is this the PACRIM case that you're referring to?
No, but I do believe that at one of the conversations, I volunteered my initial reaction that would have reflected that I was understanding they were talking about this arbitration, because I believe with perhaps 90% certainty that I told them that I believe that this arbitration may be started by the individual U.S. investors, because that was what I immediately believed when I first heard.
And you say you told that to Mr. Ali and Mr. de Grammont?
I believe so.
And where do you describe that in your witness statement?
I don't, because I'm not absolutely sure.
I see. But you are absolutely sure of everything that's in your witness statement, is that correct?
Correct.
Now, at paragraph 7 of the statement, you say, and again I quote, let's highlight that, Mr. Ali also mentioned that he had been present at a meeting with President Saka during President Saka's official visit to Washington, D.C. 1 week earlier. Do you see that statement, Mr. Prada?
Yes, I see the statement.
Did Mr. Ali describe that meeting with President Saka to you?
Yes, he did.
Did he tell you what the purpose of the meeting had been?
No.
Did he tell you that the meeting had anything to do with ICSID arbitration?
As a matter of fact, yes, and I did not put it in my statement for a reason that I will explain to the tribunal if they would like to.
Well, what's the reason?
Reason is he gave me more specific information about this meeting. I have tried since to confirm that information. That information has not been confirmed. We are in the process of trying to confirm the information, and therefore I would prefer not to mention the specific information that he gave. It's unconfirmed. We're in the process of trying to confirm, and I would not want to prejudice the tribunal with the specifics of that information unless instructed to.
Mr. Parada, on becoming hired as counsel in this case, did you attempt to obtain notes from the meeting that Mr. Ali had with President Saka?
No.
Wouldn't that have been a duly diligent thing to do if you knew that counsel for the investor had a meeting with the head of state of your client?
I don't know.
You don't know if that would have been a duly diligent thing to do?
The duly diligent thing? No, I
In
don't.
preparing for this case, in representing the government of El Salvador, and knowing that counsel for the claimant had a meeting with the president of El Salvador, you didn't think to try to obtain the notes from that meeting, Mr. Parada?
Objection as to Mr. Parada's role as counsel in this case. I think the questions should go to Mr. Parada as a fact witness, not what he did in preparing for this case.
Well, Mr. President, as fact witness, Mr. Parada has told him that Mr. Ali revealed that he had a meeting with President Saka on the very subject of this case. One would think that upon being hired as counsel, if in fact he really had learned that information from Mr. Ali, he would have said, counsel for the claimant told me you had this meeting. I'd like to, were there any contemporaneous notes kept of that meeting?
We're getting into an area where there may be legal privilege, and this is a very difficult area given that this is a lawyer giving fact evidence for the respondent. So let's take this very slowly. Could you back
Sure.
up? Just please wait a moment. Just back up to the answer that the witness didn't give to your earlier question.
Okay.
Now, that's a puzzle, obviously, to the tribunal. We don't know what the witness is referring to, but do you?
I do not know what the witness is referring to. He's testified that Mr. Ali told him about a meeting that Mr. Ali supposedly had with the president of El Salvador. I posed the question, upon being hired as counsel, did you endeavor to obtain any notes from this meeting that Mr. Ali supposedly had?
Let's go back to your first question, because
Yes.
you didn't pursue it. Do you want to ask this witness what Mr. Ali told this witness, which is what he says he's in the process of checking, and we don't understand how that checking is taking place? But do you want to pursue the question about
Yes.
what Mr. Ali told him?
Yes, let's back up to that.
Now, let's go back to the witness. We understand, obviously, that you don't want to give information, if you possibly can, that hasn't been checked. But what is the difficulty in answering counsel's question as to what you say Mr. Ali told you?
The difference, Mr. Chairman, is that it's very precise information that, if true, would completely undermine everything. And I would not like to prejudice the tribunal with that information, because everything I have been able to do so far to confirm it has not confirmed it. But we're still in the process of trying to obtain confirmation. And therefore, not only I would not want to prejudice the tribunal with saying very specific information that is unconfirmed, but also because I don't want to reveal what we are trying to do in the future.
Well, I think we have to divide your role and be very careful. We're not asking you here to give evidence about what you do or don't do as a legal representative with a respondent, but you are here as a fact witness. Now, if you can testify to the best of your recollection, truthfully, what Mr. Ali said to you, and you're going to be asked that question, as we understand, by counsel for the claimant, you should answer that question as a fact witness.
If the tribunal so directs, I will answer that question. And, Mr. Chairman, all my answers are truthful.
We're all struggling with a somewhat unusual situation, and we have the greatest sympathy with counsel on both sides, and indeed the witness. Now, as we understand it, you would like to ask this witness the question to which I've referred, namely, what did the witness understand Mr. Ali to say to him about this apparent meeting with President Saka? That's a question you wish to pursue.
That's
is
correct.
That right?
That's correct, Mr. President.
And
Well,
what-
yes, as Mr. Ali correctly says, I would like to pursue this line of questioning a little bit further. I mean, he said in his witness statement that Mr. Ali told him about this meeting. He's made certain innuendos on the witness stand as to what may have been revealed to him in that meeting. So I'd like to probe that a bit further, Mr. President.
Well, I think rather than talk about his role as a lawyer since, if you can go back to the meeting, and again, we're in your hands. You ask the questions you choose to ask. We're not telling you
Okay.
to pursue this if you don't wish to do so.
I do wish to pursue it. Thank you,
Please
Mr.
pursue
President. So, Mr. Parada, what precisely did Mr. Ali tell you about the meeting he had with President Saka?
Well, in fact, he said that he had met with President Saka, that he had talked to President Saka, and that he had told President Saka that if El Salvador did not issue the concession, they would initiate arbitration against El Salvador, then El Salvador would lose.
And where did this meeting with President Saka take place?
I don't know.
Did he tell you who else was at the meeting?
No.
Did he tell you anything else about the meeting?
No.
So, when you said earlier, Mr. Parada, that you've been endeavoring to find other information about the meeting. What is that other information you've been endeavoring to find?
Same objection as to the witness's role now as counsel rather than as a fact witness.
I'll withdraw the question. Bear with me just a moment, Mr. President. Mr. Prada, when Mr. Ali told you what he had said to President Saka, did he tell you what President Saka's reply was?
No.
Isn't the case, Mr. Prada, that the meeting with President Saka to which you're referring was actually a luncheon attended by about 300 attendees at which President Saka was the keynote speaker?
I have no way of knowing. What I know is that finally, about 2 weeks ago, counsel for Pakrim Cayman confirmed that Mr. Ali was present at a meeting, at a luncheon meeting, on November 28th of 2007, in which President Saka was the keynote speaker. I have no way of knowing that that was the meeting that he was referring to.
Do you have any reason to believe that there was a separate meeting he was referring to?
If what Mr. Ali told me on December 7th was true, and it is true that they did not speak at that meeting, like a letter from your law firm expressed, then there must have been another meeting.
Was Mr. de Gramont present when Mr. Ali told you that he had personally spoken to President Saka?
Yes.
Did Mr. de Gramont say anything in response to Mr. Ali's communicating that information to you?
I don't recall. I don't believe so.
Now, other than the two meetings that we've been talking about, the November 27th and December 7th meetings, did you have any other discussions with Kroll and Maureen lawyers about prospective employment at that firm?
I don't believe so.
Did you have any other discussions with Kroll and Maureen recruiting personnel about employment at Kroll and Maureen?
I do not believe so. No.
And did you have any other communications about employment at Kroll and Maureen with the recruiter who had set up the interview in the first place?
No, I did not.
Now, in your witness statement at paragraph 8, you state that you were invited to join the Crowell & Maureen International Arbitration Team. Is that correct?
Correct.
Now, you've attached various documents as annexes to your witness statement, but you did not, in fact, attach an offer letter from Crowell & Maureen, did you?
No, there was no offer letter.
So Crowell & Maureen didn't actually make you an offer, did they?
Not a formal offer in writing, but that's not the way these things work.
What's your basis for saying that's not the way these things work?
My basis, for example, is when I moved from Arlen Porter to LaBeouf Lamb, I did not get my letter, my formal offer, until after I had had series of discussions with the main partners at LaBeouf Lamb, Green and McRae, and they had invited me to join, and I said yes, and then they sent me the formal letter. So the conversations precede the formal letter.
So you understood an offer was being made to you even though you hadn't received a formal offer letter?
No, I understood that an invitation to consider joining their law firm was being made, and as a matter of fact, Mr. de Gramont told me that they were trying to build up their Latin American practice, and they believed that I was the perfect person to help them build up that practice.
Did Mr. de Gramont tell you what compensation you would be paid?
No.
Did he tell you what position you would be hired into?
No, we didn't get to that level because I never expressed an interest in joining them.
I see.
And normally there has to be an initial meeting of interest, and then you start discussing details. I had not even decided I was interested in joining them. I had not even started doing due diligence on themselves or on the law firm, asking questions about it, asking about what position it would be. I wasn't even really thinking of leaving my law firm.
So you didn't ask what your compensation would be?
No,
You didn't ask what position you would be hired into?
no.
And you say in your witness statement that at a conference in February of 2008, you told Mr. de Gramont that you were not the person Crowell & Maureen needed for its international arbitration team, right?
Correct.
Now, let's go back to that first meeting in November of 2007. When Mr. de Gramont and Mr. Ali each independently told you of their intention to start ICSID arbitration against El Salvador, did you immediately communicate that information to anyone in the government of El Salvador?
No, I did not.
Did you tell anyone at your law firm?
No.
And on December, at that second meeting, when you say that Mr. Ali again said that they would initiate ICSID arbitration if El Salvador did not grant the concession, at that time, did you immediately communicate that information to anyone in the government of El Salvador?
No, I did not.
Did you tell anyone at your law firm?
No.
So just so I'm clear on this, Mr. Prada, it's your testimony that you had learned information about an impending arbitration against a client you had previously represented, for whom you had conceived the winning argument in the Incesa case, and with whom you had extensive ties from an earlier partner in your career, and yet you told no one at your law firm about this impending arbitration.
Not at that time.
I
Is
see.
correct.
And on February 1st, February 1st of 2008, after you told Mr. de Gramont that you were not the person Crowell & Maureen needed for their team, did you immediately advise the government of El Salvador then that an investor was about to bring an ICSID arbitration against it?
No, I first advised Mr. Smith what I had learned.
So you-
just to expand a little bit, I take very seriously my different duties of confidentiality. And for example, I felt that I would not, until I told Mr. de Gramont on February 1st that I was not interested in the law firm, that I was at liberty to discuss what they had told me with anyone else. Then after I told him that, then I felt that then I was at liberty to tell other people, and the first people I told were Mr. Smith and others in my law firm.
And when did you tell Mr. Smith this information?
Sometime before March 7th. I do not have an exact date.
And where is that described in your witness statement, Mr. Parada?
It's not described because it's not relevant to my witness statement.
I see. And when you came to the conclusion that after having told Mr. de Gramont, after you told Mr. de Gramont that you weren't the right person for Crowell & Maureen, how did you come to the conclusion that it was okay at that point to reveal the information you had learned in the course of these interviews?
Because they would no longer be considering me as a potential attorney that would join their law firm, and therefore I was at liberty. Just for example, if you look in my emails, it wasn't until after I left Arnold & Porter that I contacted the Attorney General of El Salvador to express my views about continuing with the legal strategy that had been devised from the beginning. I didn't say anything before while I was still employed at Arnold & Porter. I waited until after I left so I could feel that I had no duty of being a lawyer with Arnold & Porter before saying something in which I was at disagreement with a senior partner.
So the duty you're referring to is sort of a personal duty that you felt?
Yes.
It wasn't something you had consulted with ethics counsel about, for
No.
example? Now, I want to go back to Annex D to your witness statement. And again, just to make sure we're all on the same page here, Annex D is that March 7th, 2008 email to the Assistant to the Attorney General, correct?
Correct.
And you send this email just over a month after you told Mr. DeGramont that you were not the right person that Crowell & Moring needed for its team, correct?
Correct.
Now, I want to explore the substance of this email a little bit more deeply, Mr. Prada. In that email, you don't get to the subject of a potential ICSID arbitration until the very end, correct? Until that third paragraph, right?
Correct.
And that's after describing your own qualifications and your having conceived the winning argument in the Encesa case, right?
Right.
And in referring to the potential ICSID arbitration, you say you want to, and again I'm going to quote here, update the Attorney General on a possible international dispute in the making at this time that may result in an international ICSID arbitration against El Salvador, right?
Correct. That's the English translation. I sent the original email in Spanish.
Right. And for ease of everyone's reference, I'll continue focusing on the English version, if that's all right with you.
The English translation.
The
yes.
English translation, correct. Now, that statement about a possible dispute in the making that may result in arbitration, that was based on information you say you learned in your meetings with Mr. DeGramont and Mr. Ali, correct?
Correct.
But in your email, you don't say that that's the basis for the update you want to give the Attorney General, do you?
The knowledge that I received.
In other words, you don't say that you want to give the Attorney General an update based on information you've learned from counsel for a potential claimant. You don't say that in the email, do you?
I don't say that, but there's no other source that I could have learned that from except from counsel working on that case.
But you don't advise the Attorney General of that, do you?
No, I don't. I normally do not reveal the sources of my information.
Isn't it possible, by the way, Mr. Prada, that the possible dispute in the making that you're referring to here is the possible dispute in the making between Commerce Group and El Salvador?
No, it's not.
But you don't identify the possible claimant here, do you?
No, I don't. But it's not possible that it was Commerce Group because I was specifically told that the company had not been granted the permit. And the Commerce Group case was very different. Commerce Group already had an exploitation concession, something that Pacific Rim never had. So it could not have possibly been the same arbitration. Commerce Group case was about the revocation of their environmental permits. Pacific Rim's case was that their application for the environmental permits and for the concession was never granted.
I see. And you knew that at the time of this March 7th, 2008 email?
No, I did not. I know it now.
And in fact, you don't mention the nationality of the investor in this possible dispute in the making, do you?
No.
Nor do you mention the sector in which this possible dispute in the making would occur, do you?
No.
Yet, in your witness statement, you say that Mr. Ali and Mr. DeGramont told you that the ICSID arbitration they intended to start involved a mining dispute, correct?
Correct.
Now, in fact, you don't even indicate in this email, do you, Mr. Prada, that the possible dispute in the making would be a dispute under CAFTA, do you?
No.
And just so I'm clear, the update that you're proposing to give the Attorney General is an update that, in fact, would be based on 3-month-old information, isn't it?
Yes, and, update may not be the most correct translation. If we look at the Spanish version, but it's probably the information to provide information to the Attorney General on a possible international arbitration.
Or are you saying this isn't an accurate translation, Mr. Prada?
Let's look at the Spanish and I can tell you.
Well, did you review the translation before you submitted this as part of your witness statement?
I did.
You did. And you confirmed that the translation was indeed accurate?
There's a difference between, because update can also suggest, and maybe we'll just agree on the meaning of the word update. Update may mean that I have said something before and I am updating the information, and that was not the case. This was the first time I was telling the Attorney General. But
Okay.
if we don't understand that, the word update is correct.
Okay. So in fact, given that you were seeking to win business from the government of El Salvador, if you really had learned about this possible dispute in the making from counsel for the potential claimant, wouldn't you have said that in the email?
Not necessarily.
Wouldn't you at least have given a little more detail about this possible dispute in the making, Mr. Prada?
No.
Now, you received a reply from the Attorney General, in fact, within hours of sending this email, correct?
Correct.
And that's Annex E to your witness statement, right?
Yes.
Let's put Annex E up on the screen there. Now, this reply from the Attorney General doesn't mention the possible dispute in the making, does it?
No, it doesn't.
And in fact, it doesn't ask for the identity of the investor in that possible dispute in the making, does it?
Correct.
Nor does it, nor does the reply ask in what sector this possible dispute in the making was occurring, does it?
No, it doesn't.
In fact, the Attorney General in this reply doesn't even mention ICSID arbitration at all, does he?
Correct.
And you mentioned earlier that he wasn't able to meet with you when you put in this request. In fact, he doesn't even set up a date for a meeting in the future, does he?
No, and I actually sent a subsequent email that was not an annex to my witness statement, in which I offered to move my trip either at the beginning or the end so I could meet with him, and he did not reply.
And why didn't you attach that subsequent email as an annex to your witness statement, Mr. Prada?
Because I did not believe it was necessary. I was not required to do so, but if you would like, I can give you a copy of it.
Well, so you selectively attach certain email correspondence to your witness statement. Is that what you're saying,
That's
Mr.
correct.
Prada?
That's
And you
correct.
decided what was relevant and what wasn't relevant, is
Yes.
that correct? So, in fact, there was other correspondence concerning this pursuit of business with the government of El Salvador that you chose not to include with your witness statement, is
Yes.
that correct? Thank you. And, Mr. President, I think we would request that at the close of this session, that additional correspondence be produced to claimant.
Let's address that right now, because it may be unique to it for cross-examination. Do we have these documents or document
No, not
available?
not-
I'm not asking you, forgive me. I've got to deal with this through counsel. Let's ask,
Okay, now, Mr. President, we do not have the documents with us at this time. We would certainly be able to produce them later on, but they would have we would not have copies at the moment because the determination was made that they weren't relevant to the response, and so they were not provided. But we would certainly have no qualms about providing all of the additional documents.
where are these documents as we speak?
Well, they would be if they're emails, they would be in the email system of the law firm, and would have to be searched out and printed.
Could that exercise be begun now with one of your colleagues?
Yes.
Let's do that.
Yeah, okay.
I like to say that I have those emails already separated in case the tribunal's order was more inclusive than it was. I was going to present all those emails. They're already separated in an electronic file in my laptop. So I believe I can produce those emails this afternoon,
Well, where's your laptop as we speak?
right there.
Could you forward them on to the Secretary of the Tribunal, and he can print them out?
At this moment,
Yes.
if I can establish an internet connection.
Now, that's not
perhaps.
so easy down in this fourth floor basement, but we'll try.
That's what I understand. I would.
Let's just stop a second. How many documents are we talking about? Well, let's just sort it out, then we'll take a break.
We're talking about perhaps 10
10 documents.
10 documents, mostly emails to other government officials, for example, the Minister of Foreign Affairs of El Salvador and the legal secretary to the President of El Salvador.
What do you
Chairman,
suggest?
You know, the documents that Mr. Prada is describing and he's saying that he made his own determination weren't relevant to his witness statement, at least from the description here, sound like they're entirely within the scope of the document production request that claimant made to the tribunal and that the tribunal ordered respondent to turn over. The fact that these documents, the existence of which we've just learned about, are being produced to us here on the spot at this cross-examination, naturally that handicaps claimant quite a bit. We'll certainly take the time to review them and incorporate them into our cross-examination if we're able, but I would simply point out that this really does prejudice claimant's ability to cross-examine this witness.
What do you suggest the tribunal orders?
At this point, Mr. President, I think probably the best solution would be for me to resume with the cross-examination now, review the additional documents to the extent I'm able over the lunch break, and perhaps.
Don't speak to anybody for the moment.
I'm not sure what that was all about, but I think.
Calm down.
And perhaps.
Please don't speak to anybody for the moment. Please continue.
What I was going to suggest, Mr. President, was we could review the documents over the lunch break. I don't know how voluminous. I mean, 10 could be 10 single emails, 10 could be a lot of pages, obviously. Also, depending on the contents of those 10 documents, they may require additional research and investigation on our part, which we may or may not be able to complete over the course of the lunch break. But, assuming we're talking about a relatively small volume of documents that we can absorb, assimilate, and then resume with the cross-examination on, then as a sort of least bad solution, I would suggest that we be allowed to continue with the cross after the lunch break.
One further question for you, Mr. Parada. Your laptop is here.
Yes.
If we broke now for 10 minutes, do you think you could forward the documents you're describing to the tribunal secretary, at least to start the printing process? They could then be disclosed to the claimant. We wouldn't necessarily admit them in evidence until we heard the parties further. But before we talk about whether that's right or wrong, would that be physically possible for you to do in a few minutes?
Perhaps 15 at most, 15. And I perhaps would prefer, because the internet connection might be a problem, if we could have a memory stick, I could just transfer them.
We can do a memory stick straight away.
And just to clarify, Mr. Chairman, we're talking about documents that are not responsive to the tribunal's procedural order. These are documents
let's not argue that for the moment. We're just talking about the logistics. So USB, we could take a short early break now and get that moving, and then we could continue with the cross-examination. Is there any objection to that course from the respondent?
The respondent has no objection to that course.
And the claimant?
No, we have no objection, Mr. President.
Well, what we'll do is we'll break early for coffee now. I appreciate it's in the middle of your cross-examination, and I know that's awkward, but this is the least of two evils. We'll give you a USB stick, and if, without talking to anybody else except the secretary to the tribunal, you could download these documents onto the USB stick. The secretary will then get them printed out for both sides, but not yet the tribunal. And then we can take it from there. You can start your review whenever you want, and we can see what happens. You may decide not to pursue it. You may think some documents are relevant. You may think none are, but at least we'd get over this hurdle. So we'll break now for 15 minutes. It's now 10:05, and we'll go on to 10:20. There's one matter which I've just been reminded of. I assume these emails are in Spanish.
Yes.
Is that going to cause any difficulty? I hope not.
It will for me, personally. However, we do have Spanish-speaking colleagues who can step in, fill the gap.
Fine. Well, let's break now, and we'll ask the secretary to approach.
Mr. Chairman, if you could please give the witness the microphone. If you could please give the witness the customary instruction about not speaking to anyone.
During the break, please only speak to the secretary to the tribunal. We will say this to all witnesses, but when witnesses are being cross-examined during their time at the table, we do not wish them to talk about the case to anybody except in the presence of the tribunal.
Mr. Chairman, may I add just a short statement? Just for the record.
Please do.
What I communicated to counsel while you were discussing was merely what I just said to you, that these emails are outside the temporal scope of the tribunal's order, just to clarify.
Fine. Well, for the moment, to avoid any possible misunderstandings, please don't speak to anybody except for this purpose to the secretary of the tribunal. Thank you very much. So we'll break for 15 minutes. Let's resume.
Mr. President,
Let's resume. Before we take any further step, I'm going to now call upon the Secretary of the Tribunal to describe what has been achieved during the break.
Thank you very much, Mr. President. On behalf of Exit, I can confirm that I received from Mr. Parada a USB drive containing 12 documents. I have provided a copy, an electronic copy to each party, and we are also providing a hard copy in a few minutes to both parties.
These documents have not been, at our request, shown to the tribunal. They are at the level of disclosure between the two parties. Whether they should come into evidence will be the subject of a further application to be considered by the tribunal in further consultation with both parties. Now, is there anything that needs to be raised? The respondent first.
yes, Mr. President, I would just like to point out that we have now had a chance to briefly review these documents. They are all documents from between March 7, 2008 and December 22nd, 2008. The tribunal's order for production of documents indicated all documentation of whatsoever nature coming into existence during the period from 30 October 2007 to 31 December 2007. Therefore, they were not produced because they were not responsive to the tribunal's order.
Just to make sure there's no misunderstanding, we understand that this production was a voluntary production by the respondent. It was not subject to an order made this morning by the tribunal. That's
This production
correct, isn't it?
was a voluntary production from respondent, yes.
Now, turning to the claimants, we understand that, Mr. Posner, you're willing to proceed further with your cross-examination, subject to coming back when you and your team have had a chance at the end of your cross-examination to look at these documents. Is that correct?
That's correct, Mr. President.
Now, we have a further request to all of us, and I mean all of us, from the shorthand writer and the translators. Could we please, all of us, speak more slowly? I hope that lesson is well taken. Let's proceed.
Thank you, Mr. President. Mr. Prada, when we broke, we were looking at Annex E to your witness statement, and I'd like that put back up on the screen. And again, just to make sure that we're all on the same page, this is an email that you received from the Attorney General of El Salvador on March 7th, 2008, correct?
Correct.
And in this reply, the Attorney General doesn't mention the possible dispute in the making that you had referred to in your email, correct?
Correct.
And he doesn't ask for the identity of the investor in that possible dispute, does he?
No, he does not.
In fact, he doesn't even mention ICSID arbitration at all, does he?
No.
And I think we established earlier that he doesn't even set up a date for a future meeting with you, right?
Correct.
Now, Mr. Parada, if there was actually a dispute with the prospect of arbitration coming imminently, wouldn't the Attorney General have wanted to set up a meeting with you right away?
Objection as to the thinking of the Attorney General, which is outside of the competence of Mr. Parada's knowledge.
I'll withdraw the question, Mr. President. It would appear from the Attorney General's response, would it not, Mr. Parada, that the prospect of impending arbitration against El Salvador was not a concern of his at this time, was it?
I would have no way of knowing.
Well, I'm simply asking you to tell me how you understood this email.
I understood the email saying that he could not meet with me on those dates.
Mr. Parada, let's turn now to Annex F to your witness statement. And this is another email you sent to the Attorney General 1 month later, correct?
Correct.
And in that email, you asked for a brief meeting between you and your boss, Mr. Smith, and the Attorney General, correct?
Correct.
And here, one of the things you proposed to discuss in that meeting is, and again I quote, an ICSID arbitration against the Republic of El Salvador that might be initiated under the CAFTA framework, correct?
Correct.
Now again, you don't identify the investor that might initiate that arbitration, do you?
The email does not. No.
Are you saying that that information was communicated outside of the context of this email?
No, I'm just answering your question. You asked me if I'm communicating, and I'm saying the email does not reflect that.
I see. Now, again, isn't it possible that your reference to an ICSID arbitration that might be initiated really is a reference to the Commerce Group arbitration?
No, it's not.
But that's not evident from the context of the email, is it, Mr. Parada?
I suppose not.
Now, you don't even identify the nationality of the investor that might initiate this arbitration, do you, in this email?
No, I don't.
Nor do you identify the sector involved in that arbitration that might be initiated, do you?
No.
Nor do you indicate when that arbitration might be initiated, do you?
I have no way of knowing that.
And you didn't receive a response to this email, did you?
I believe not, but in the emails that you will receive shortly, there are a lot of, several of those are emails in between the ones I have submitted. I do not believe this particular one may have been, but there will be perhaps a response. There, just to clarify, there are further responses from the trying to set up this meeting with the Attorney General between me and the Administrative Assistant to the Attorney General. I'm not sure if this particular email was replied to, but you will be able to see that in the document.
But presumably, if you had piqued the Attorney General's interest with your April 8th email and he said, yes, I want to learn more about this impending ICSID arbitration, you would have attached that response to your witness statement, would you have not?
Correct.
Now, this email, this April 8th, 2008 email, was sent about a month after publication of press accounts in which President Saka was quoted as saying that he was not in favor of granting those permits, meaning mining-related permits, correct? Which we've discussed with some frequency in this arbitration. Is that correct?
I'm not sure I will agree with your characterization, but this was sent after the March 11 newspaper articles that reported some statements by President Saka.
Isn't it the case, Mr. Prada, that it's those articles that prompted you to send this email to the Attorney General?
Not at all.
Let me turn to Annex J to your witness statement. And this is a July 9th, 2008 email you sent to somebody named Ms. Elizabeth, and I may be mispronouncing the name, Villalta. Is that correct?
Elizabeth Villalta,
Villalta.
and she was the legal advisor to the Ministry of Foreign Affairs.
I see. And in that email, you say, and again, I'm going to quote, this is the first highlighted quotation here, I became aware of this dispute and that the company was contemplating arbitration since January. Is that correct?
That's what the email says.
But you don't say how you became aware of the dispute in January, do you?
No, I don't.
You mentioned earlier, I believe in your direct testimony, or maybe it was during the course of my cross-examination, that you had been following press accounts about mining in El Salvador, correct?
I was following press accounts about anything in El Salvador, and I had been aware of that there was a dispute brewing.
And you were aware, weren't you, that in January 2008, Pacific Rim Mining Corp., that is the parent of the claimant in this case, had issued a press release referring to protections under CAFTA, weren't you?
Not at the time.
You only became aware of that press release after this case began?
Yes.
Let's turn to Let's turn to Annex K to your witness statement, Mr. Parada. And this is another July 9th, 2008 email to the same Ms. Vialta, correct?
Correct.
And in that email, you say that you had, and again, I quote, just completed preliminary research and found that the company in question, Pacific Rim Mining, is Canadian, not a U.S. national, correct? Do you see that statement?
Correct.
Now, earlier, when you were testifying about your meetings with Mr. Ali and Mr. Degremont in 2007, you said that they had told you that the investor in this possible dispute in the making was Pacific Rim Mining, correct?
That's not correct.
That's not what you testified earlier?
No.
So you're saying, and I'm sure we can all go back and confirm this in the record, but you're saying that when you met with Mr. Ali and Mr. Degremont, neither of them told you who the investor was in this potential dispute in the making?
That is correct.
So was this the first time in this July 9th, 2008 email, was this the first time that you were aware that the company in question was Pacific Rim Mining?
Perhaps not with the name, but what caught my attention was that this email was sent 2 days after the existence of the dispute, the hiring of Crowell & Mooring, and the mention of potential arbitration became public knowledge. And that Global Arbitration Review article, where I learned that, said that the company was U.S. And so that led me to double check deeper, and that's when I confirmed that it was not U.S., that it was Canadian.
Well, let me ask my question again, Mr. Prada, because I don't think you answered it. Was this the first time that you were aware that the company in question was Pacific Rim Mining?
I do not believe it's the first time, but I cannot tell for sure because the press reports that I had read before may have mentioned the name Pacific Rim Mining.
But just to be clear, just so I'm absolutely sure about this, you're saying you didn't learn that the company at issue was Pacific Rim Mining when you met with Mr. Ali and Mr. Degremont, correct?
I did not learn it from them, no.
And you may have learned it at some point between those meetings in 2007 and this July 9th, 2008 email, correct?
Or I may have even learned it before if I read it in the newspaper, the press. I was just aware that there was a Canadian mining company that had an issue with the government of El Salvador. I'm not sure if I remember or knew the name of Pacific Rim Mining.
But in any event, you just completed your preliminary research in July of 2008, correct?
Completed a preliminary research, yes.
I see. So you had not done any preliminary research on the company before sending your email to the Attorney General in March 2008, correct?
I may have done some preliminary.
What preliminary research did you do before sending that March email?
I am not, I'm not sure.
Did you investigate the ownership of the investor at issue?
No.
Did you investigate the size of the investment?
No.
Did you investigate when the investment was made?
No.
So let me pose the question again, Mr. Prada. Did you do any preliminary research before sending that March 2008 email to the Attorney General?
I may have.
But you don't recall what kind of research you did?
Not at the level that you mentioned. No. If I conducted any research, it would have been at a more general level than what you mentioned.
And this was general research you were conducting in order to give the Attorney General an update on information concerning a possible dispute in the making, correct?
Just to know, because I wasn't really going to go in to do a more in-depth research until I got an appointment with the Attorney General, which I never did.
I see.
Until December 2008.
Now, let's turn back to this Annex K. I'm looking a little bit further down in that same paragraph we were examining before, and I'm focusing in particular on the very last sentence in that paragraph where you say, and I quote, "It definitely seems like they are laying the groundwork to initiate arbitration in the medium term if their plans are not approved." Do you see that statement?
Yes.
So am I correct, Mr. Prada, that it was your understanding at this point in July of 2008 that the prospect of arbitration was still speculative, correct?
I'm not sure what you mean by speculative.
I'm asking, based on this statement, is it fair to say, based on this statement, Mr. Prada, the one that's just been highlighted, that your understanding here in July of 2008 was that the prospect of arbitration was still speculative. It could happen, it might not happen.
I would not say speculative, I would say it was possible, but not certain. The announcement itself said that if the company did not receive the permit, they would initiate arbitration. So there was no certainty that there would be arbitration.
I see. Now, just to be clear, even though in this email from July of 2008 you do give some detail and analysis based on your preliminary research, you still don't mention anything about your having learned about this dispute from counsel for the company, correct?
Correct.
And let me just ask again, just so I'm clear on this, Mr. Parada, if you were trying to get hired by the government of El Salvador, wouldn't it have made sense to let them know at this point that you had information about the impending dispute from the lawyers representing the company?
No.
And why wouldn't that have made sense, Mr. Parada?
I did not normally reveal the sources of my information. I just revealed the information.
Don't you think it would have made you more attractive as a potential lawyer for the government if they knew that you had special information you had learned from counsel for the would-be claimant?
No.
Let's turn to another annex to your witness statement, Mr. Parada, and this time I'm looking at Annex L. Let's magnify that a little bit. Good. So, Mr. Parada, this is a July 11th, 2008 email you sent to a partner at Dewey LaBeouf, Mr. Don Picard, regarding upcoming travel to El Salvador, correct?
Correct.
And in that email, you say, and this is highlighted, that you're going to meet with government officials regarding a dispute I have known about for a couple months, correct?
Correct.
So you learned about the dispute a couple months before July 11th, 2008, right?
That is a figure of speech, a couple of months, a few months. The point that I was trying to make is that for the first time, that dispute had become public knowledge in the 9 days since July, and that I had known about this dispute before. So the expression a couple of months is just enough to say that I had learned about this dispute before it became public knowledge.
So you weren't being very precise in your language here, were you?
Correct.
But you were being precise in your witness statement, I take it?
Yes.
Let's turn to Annex N to your witness statement, Mr. Parada. And let's magnify that a little bit more. This is a trip report you sent to partners at Dewey and LaBeouf in July of 2008 after your travel to El Salvador, correct?
Correct.
And here you say, and again, this is the sentence that's highlighted, I had learned about the dispute a few months ago, right?
Correct.
Was that also imprecise language, Mr. Prada?
Yes.
Now, Mr. Prada, we've gone through a series of emails between you and officials in the Salvadoran government and between you and your colleagues at Dewey and LaBeouf. And in not a single one of them do you refer to your meeting with Mr. Ali and Mr. de Gramont in 2007, do you?
No.
In fact, the only time you say that you learned about this dispute from Mr. Ali and Mr. de Gramont is in the witness statement you submitted in this dispute in which you're counsel for the respondent. Isn't that correct?
There's no other way I could have learned about this dispute but from them. That is the only time that I say it is in my witness statement in writing. I had told Mr. Smith before that I had learned it from Mr. Ali and Mr. de Gramont.
But you don't reveal that in your witness statement, do you?
No.
So the first time you've told us that you told anybody that's how you learned about this dispute is just now in this hearing, correct?
Can you ask that question again?
Sorry. You testified a moment ago that in none of the writings that we've reviewed do you reveal that the way you knew about this dispute was from your conversation with Mr. Ali and Mr. de Gramont.
That's correct.
And you do say in your witness statement that that's how you learned about this dispute.
Yes.
And you testified a moment ago that notwithstanding the absence of that reference from these various written communications, you did tell Mr. Smith that that's how you were aware of this dispute, correct?
Correct.
But you don't say in your witness statement that you had these conversations with Mr. Smith, do you?
No.
Okay. Now, sorry, Mr. President, may I have a moment just to confer with my colleague? Mr. President, I'm nearing the end of this portion of the cross-examination, subject to, of course, the review of the additional documents we've just received. So if I may proceed, I just have a few more questions for Mr. Prada.
Please proceed.
Mr. Prada, I want to go back and revisit a couple of the lines of questioning we've pursued this morning. First, I want to go back to what you testified earlier about your departure from Arnold and Porter. You said, and correct me if I'm misremembering here, I believe you said you left Arnold and Porter over disagreements about strategy in the Incesa case, correct?
That's correct.
But isn't it also correct that they ended up adopting the strategy that you had advocated?
Yes. Actually, the strategy had already been adopted, and people were trying to change it. And I was advocating to continue the strategy. So after I left Arnold and Porter, I communicated with the Attorney General of El Salvador, advocated with him directly to continue the strategy. He then told Arnold and Porter to continue the strategy, and that is the strategy that was continued, and that's the strategy how the case was won.
So your testimony is that Arnold and Porter continued with that strategy because of your intervention with the Attorney General?
Because of the Attorney General's decision to continue with that strategy.
On the basis of your communication with him, correct?
Yes.
So it's because of your intervention that Arnold and Porter resumed with that strategy?
Objection.
It was never abandoned.
Objection. I don't see how Mr. Parada can know the thinking of Arnold and Porter after he was no longer their competence.
That's a fair objection, isn't it?
That's fine. I'll let that go. Thank you. The second line of questioning I'd like to revisit briefly, Mr. Prada, is the meeting with President Saka that Mr. Ali told you he had. Now, Mr. Prada, you've worked extensively in the Salvadoran government, correct?
I worked for 15 years as member of the Army of El Salvador. During that time, I had assignments at the embassy and the Ministry of Foreign Affairs, if that's what you mean.
That is what I mean, indeed. And in your experience, Mr. Prada, when the president holds a meeting with somebody, there's normally a formal agenda that's kept, correct?
That's not correct.
That's not correct. Are there any documents that are normally kept in the ordinary course of business to document that a meeting was had by the president with a private citizen?
Depends what type of meetings that is. When I was assigned to the Embassy of El Salvador in Washington, D.C. for 4 years, I had the privilege of accompanying the President of El Salvador on several of his visits, and this is not President Saka, but President Cristiani. And I know for a fact that there, in addition to the scheduled meetings in the agenda, there are numerous meetings that happen that are not on the agenda, that are one-on-one, and on which records are not kept.
And when those meetings that are not on the agenda are held, are minutes kept of those meetings?
Under President Cristiani, that's the only personal knowledge that I have. Meetings that he had, for example, at the hotel where he was staying, meetings I participated on, there was not records kept of those meetings.
There wasn't even a note taker present at those meetings?
No.
So is it your testimony, Mr. Prada, that what Mr. Ali told you he had was one of these informal private meetings with President Saka?
First of all, I have no way of knowing if what Mr. Ali told me is true. Second, in other words, I don't know if he actually met with President Saka or not. But second, I have no way of knowing if it was one of these meetings or not.
Now, Mr. Parada, at the beginning of your testimony, when we were talking about this information that you say Mr. Ali and Mr. Degremont told you about impending exit arbitration, you said, I believe, that you thought they had told you this with the expectation that you would communicate that information to people in the government of El Salvador in the hope of possibly resolving the case, correct?
Correct.
Now, can you tell me, Mr. Prada, why you would have come to that conclusion if you understood that Mr. Ali had personally communicated that information to President Saka?
And I've already been in this situation where somebody is trying to convey a message to a high government official on something that would happen. And normally when that is done, it's done through multiple avenues. One example, the ambassador of the United States in El Salvador once asked me to convey a very serious message to the Minister of Defense of El Salvador, and put me in a very difficult position. I went and conveyed the message. Minister of Defense thanked me for not having been afraid to convey the message, and he said that I was the second person that was giving him the same message.
But even though you understood Mr. Ali had communicated personally with the President of El Salvador, you felt he was reaching out to you to supplement that communication? Is that your understanding?
I felt that may have been a possible reason why he was telling me this.
And why would he have needed to tell you this if he had personally communicated this to the President of El Salvador?
Objection calls for speculation.
Well, Mr. President, Mr. Prada has already testified about why he thought this communication was being made to him. I'm just trying to probe that a little bit further.
If you want to pursue this, you've got to rephrase the question. The way it was put is not a question for this witness.
Mr. Prada, just so I understand, you testified earlier that Mr. Ali told you about a personal meeting he had had with President Saka, correct?
Correct.
And I take it was your understanding that in that meeting, Mr. Ali had talked about this possible dispute in the making, correct?
That he had told President Saka that there was a potential arbitration against El Salvador, that he threatened arbitration if El Salvador would not give the permit.
So my only question is whether you have a view as to why Mr. Ali would have revealed this information to you with the view of your communicating to the government of El Salvador if Mr. Ali had already communicated that information to President Saka as you understood it.
My view would be, again, that if that was the reason, he would be telling me that, because there might be other possible reasons. Another one would be to entice me to join their law firm, because he was having all these contacts at high level. But if that was the reason, I believe it would have been to have the same message get through different levels, different ministries of the government. For example, who I would have given this information to, had I given it to, would have been to somebody at the Embassy of El Salvador, who would pass it to the Ministry of Foreign Affairs, or, as I did, pass it to the Attorney General.
And if you believe that that's why Mr. Ali and Mr. de Gramont each independently revealed this information to you, why did you wait until March of 2008 to say anything to officials in the government of El Salvador?
Until February 1st, I did not feel personally at liberty to reveal any of the information that I was being given, because they were still considering me, like Mr. de Gramont, for example, wanted to hire me with or wanted to invite me to be hired with the expectation that I would build up their international arbitration practice in Latin America. So first I had to wait until I definitely gave him a no answer, that I was not interested.
But you said, did you not, that you believed at the time the reason Mr. Ali and Mr. de Gramont were revealing this information to you was precisely so that you would go out and tell officials of the government of El Salvador, right?
I don't think I said that I believed that's what they were telling me. I was speculating that might be a reason why they were telling me. And again, I didn't have a duty either to do what they told me or they would wanted me to do when they wanted to do it.
Mr. Prada, just a small factual point that you testified about earlier in your testimony. I believe you said you were admitted to the bar in 2001. Is that correct?
I was admitted to the Virginia bar in 2001, I believe. Then I was admitted to the bar of the District of Columbia. Subsequent to that may have been in 2002.
I see. So you were admitted to the bar in Virginia in the same year that you graduated from law school, is that correct?
Correct.
Are you admitted to any other bars?
The District of Columbia bar.
Any other bars?
As far as states, no, if that's what you understand by bar.
That's what I understand by bar, correct. Mr. Prada, I have one last question to you. I submit to you, Mr. Prada, that what Mr. Ali and Mr. de Gramont said to you in their screening interview of you in November and December 2007 is not what you describe in your witness statement, but that rather, knowing about your extensive work on behalf of El Salvador, they asked whether, in principle, you would be uncomfortable representing a client with interest adverse to El Salvador. Isn't that what really happened, Mr. Parada?
Objection. Counsel is testifying.
I don't think he was testifying. He was putting to a witness a statement which the witness can agree with or disagree with. So please proceed.
I do believe that at some point they asked me if I would be uncomfortable working in a case against El Salvador.
And isn't that, in fact, what happened, Mr. Parada, rather than the characterization that you give in your witness statement? Of
No,
what
that's
transpired?
part and consistent with what happened.
Well, if they did pose this question to you about whether you would be uncomfortable representing a client adverse to El Salvador, how did you respond?
I believe I may have responded that I probably would be uncomfortable, that perhaps, I would be fine with assisting, trying to solve a dispute before resulting to arbitration, but I would be uncomfortable, and that's one of the main reasons why I would not even consider joining them. I would be extremely uncomfortable working on an exit arbitration against El Salvador.
And did you tell them that you had this discomfort? Did you say that at the November 27th meeting?
I don't recall which one.
So, right. So it's your contention, Mr. Prada, that Mr. Ali and Mr. de Gramont invited you to join Kroll and Maureen, even though you had told them that you would be uncomfortable representing a client adverse to El Salvador. Is that your testimony?
It might be.
It is your testimony, or it might be your
No,
testimony?
it might be that they told me that in spite of. I don't know what your.
I'm
comments-
asking what your testimony is. Is it your contention, Mr. Parada, that you were invited to join this law firm, Kroll and Maureen, notwithstanding the fact that you had told Mr. Ali and Mr. de Gramont that you would feel uncomfortable representing a client with interest adverse to the government of El Salvador? Is that your contention?
Yes, because that was not their only case, and Mr. de Gramont actually told me, and he's free to deny it if he would like, that they wanted to build up a Latin American practice, which goes beyond this particular case.
Mr. President, bear with me one moment. I may have one or two further questions. Mr. President, I have no further questions at this time. Of course, after reviewing the new documents that have been produced to us, I may have further questions and would ask the tribunal for its indulgence so that I might be able to resume the cross-examination this afternoon.
Well, would it be more convenient to you to take time out now to review the documents, and then you can complete your cross-examination before we have redirect examination from the respondent?
I actually haven't seen the documents yet, so I don't know how voluminous they are.
This is the pile. Mr. Chairman, it isn't a very large pile, but it probably will take us about 20 minutes to review them. I think that if we took a half-an-hour break.
Let's take a half-an-hour break, and if you need longer, let us know. If it's shorter, sorry. Let's take half-an-hour break. If you need longer, let us know, and if you need less time when you finish, let us know too. That would cause no difficulty, I hope, to the respondents. It would seem to us better to finish the cross-examination before we had the redirect. But if there are obviously different views, tell us.
No, respondent agrees.
Good. We're going to break now for half an hour, and we're going to ask you again, please don't discuss the case with anybody until you come back before the tribunal in about half an hour's time. Do you
Mr.
understand
Chairman, I would like to just address one small issue with regard to the documents that I provided to the Secretary of the Tribunal. Those documents are numbered, and there is a break in the sequence of the numbers. It goes from 9 to, I believe, 16. There are documents in between those that I did not give a copy because those involve the actual negotiations of the contract with the government of El Salvador that I would prefer not to disclose.
We understand that. If necessary, we'll come back to that. Let's break now for 30 minutes, and let us know what the position is when you know. let's resume. What's the position, we ask, of the claimants?
Mr. President, we have had a chance to review the documents that Mr. Prada has provided. There is one, which is an email, I guess, from March 7th, 2008, continuing, I guess it's connected to an email that comes on March 10th, 2008. I would like to ask the witness a couple of questions about that document, and for that purpose would like to have that admitted into the record. There is a second document, which is an email exchange that begins on December 17th, 2008, and continues through December 22nd, 2008. I may or may not want to ask Mr. Prada about that document, depending on what he's able to recall independently without that document before him.
And from that, I take it at least you'd like to put those documents into evidence before the tribunal.
At a minimum, the first one, well, yes, to make it easier, yes, I'd like to put both into
Is
evidence.
there any objection to that application from the respondent?
No objection.
Well, let's receive copies of those two documents. We don't need copies of the others. And is it appropriate or convenient for you to continue your cross-examination now along those lines?
It probably would be best for the witness to have at least the first document before him.
It certainly would, as always. Thank you for your patience. We seem to have sorted it out. But it's been time well spent.
May I just make one comment? Since the document being referred to is in Spanish and Mr. Bedini does not speak Spanish, I would ask the permission of the tribunal to be momentarily the person who would be defending Mr. Parada during this.
Well, even better than that, we're going to put these documents before the interpreters.
Okay.
And we would like the interpreters to read into the transcript their translation of at least the first document. We'll see if counsel is going to cross-examine on the second document.
Thank you, Mr.
So the document should be given to the interpreters and to the witness
Has it been given?
and to the tribunal.
Oh, okay. Mr. President, do you want it read in before I proceed with my questioning, or?
Well, I was going to ask you just to help us. Now we've received the exhibits marked C93 and C94. The document on which you're going to cross-examine for certain, is that C93?
That's correct.
And how much of that would it be appropriate to translate? The whole thing
Well,
or just a paragraph?
I'm not going to ask Mr. Prada about particular statements in the email. I'm going to ask him generally about the email and how it fits in with correspondence that I questioned him about earlier.
Well, I think nonetheless it may be appropriate to have the whole email translated into the transcript. I'm speaking to the interpreters, but I can't hear what they're saying. But have the interpreters got C93 before them? Yes. Could we ask the interpreters then to look at C93, and we see it's an email to Mr. Parada, and if we can start with the lines below subject and have that interpreted up until Mr. Parada's name at the bottom of the page, translated.
Dear Mr. Safi, thank you very much for a kind message. I'm sorry that our travel plans do not really match. I could change my plans to arrive in El Salvador on Tuesday the 11th in the continental flight that arrives at midday. If it were possible, we could meet on that day after 4 o'clock p.m. I could also try and change the return flight to travel on Tuesday the 18th, and then we could meet on Monday the 17th. However, I understand that you are going to have a very full agenda, both the day before the trip and the day in which you're coming back. So I deem that the most wise thing to do would be for you to tell me of other possible dates for us to schedule a meeting in the next few weeks. I would then travel again to El Salvador, perhaps in the company of my boss, Derek Smith, who speaks Spanish, and we could meet there with greater convenience. On the other hand, in connection with the success that immigrants of Salvadoran origin have had, I would like to tell you that the law firm in which I work has given me the opportunity to conduct legal work that is gratuitous in nature, or pro bono, for the immigrant community. Through the work that we have conducted, we have helped a number of Salvadoran students so that they can go to university, because we feel that that is one of the best paths to success. Our work has been focused on the access of immigrant students to universities in the state of Virginia, because there are many legal obstacles on their way, particularly in the state of Virginia. Thanks to this effort, last year, state authorities changed the regulations to allow all students with TPSs that reside in Virginia, most of them of Salvadoran origin, to attend university, paying for university fees as if they were state residents. This change favors 200 students per year. For most of them, this change represents a difference between attending university and not attending, because the cost of university studies is drastically increased from $6,000 a year, which is the amount paid by state residents, to $18,000 a year, which is the amount paid by non-residents. I'm including here the internet link of an article that was published in a Hispanic newspaper of the Washington area to give notice to all students of the area of this favorable change. The link is the following, and then an internet link follows. This article also appeared in the Washington Post. An internet link follows. At this time, we're working on a draft bill to give students the opportunity, to give students who have not received permanent residence the opportunity to attend universities in Virginia. The bill was approved by the state Senate, and it is being negotiated with the state Chamber of Representatives, or House of Representatives. I await your news in the next few days about what the best dates are for a meeting. Meanwhile, please receive a very warm greeting, and I would like to wish you success in your trip. Cordially, Luis Parada.
Just for completion, could we ask the interpreter to translate the gracias line at the top of the email as well, please? Then I think it'll be fully translated, and we're going to ask Mr. Smith whether he's content with the translation for his side.
Thank you for your email. Definitely, it will have to be later on.
Respondent has no objection to the translation.
Well, we got it on the email. You mean the interpreter? Or?
No, because it says thanks you for your
No,
message.
it's here. It's here. It's here.
Yeah, but it's the
Well, no, but we've got
Attorney
it.
General.
Yeah, okay.
Okay. Mr. Prada, you have before you Exhibit C93, correct?
Correct.
And I'd like to just put this into context. Earlier today, we talked about an email exchange between you and the Office of the Attorney General in El Salvador. This was Annexes D and E to your witness statement, correct?
Correct.
And am I correct to understand that this new exhibit C93, that is, there are actually two emails in here. I'm referring to the one from March 7th, 2008 at 4:07 p.m. This is your reply to what was in effect Annex E to your witness statement, correct?
That's correct.
Mr. President, I believe that the email he's referring to has not been translated. Okay.
C93 is what was just translated.
C93 is two email messages, and counsel was referring to the second one on that page, which has been translated.
Right, right. So just so I understand, Mr. Prada, the March 7th email within C93, that's your reply to the Attorney General's email, which is Annex E to your witness statement, correct?
That is correct.
Now, Mr. Prada, earlier you testified that after the February 2008 conversation with Mr. DeGramont, in which you said that you weren't the right person for the Kroll and Maureen team, that after that point you felt no obligation to hold confidential the information you had learned in your meetings with Kroll and Maureen, correct?
Correct.
And in fact, I believe you testified earlier that at that point you jumped into action. Those were your words, correct?
I don't remember. It wasn't at that point. It was actually several weeks later.
Okay, but at that
I
point,
started action, actively trying to contact the government of El Salvador.
and the first active attempt to contact the government of El Salvador was the email from earlier on this day, March 7th, that was Annex D to your witness statement, correct?
The first attempt to contact the government of El Salvador was the email I sent to Mr. Luis Aparicio at the Embassy of El Salvador, trying to get the contact information for the Attorney General.
I see, but the first, am I correct that the first substantive contact once you received the email information was your Annex D to your witness statement, is that correct?
Yes.
And just to refresh my memory, that's the one in which you referred to the possible dispute in the making that may result in arbitration, correct?
Correct.
Now, Mr. Prada, in the email that we've just examined from later that day on March 7th, the document that's now been marked C93, you make no reference to the possible dispute in the making that you had learned about from Mr. Ali and Mr. DeGramont, do you?
I make no further reference to that dispute, no.
Isn't it the case, Mr. Prada, that if you had significant information at your disposal and you were keen to get this representation from the government of El Salvador, wouldn't it have made sense to reveal in this further email exchange with the Attorney General the significant information that you had in your possession?
No.
Mr. Prada, I'd like to ask you one last question. When did you finally meet with the Attorney General of El Salvador?
December of 2008.
Thank you, Mr. Prada. In light of Mr. Prada's testimony, Mr. President, we won't need to pose questions about the document that's been marked as C94.
Thank you very much.
And I believe that's all we have at this time, subject to recross.
Well, let's proceed to the re-examination or the redirect by the respondent.
Thank you. Excuse me. Thank you, Mr. President. Mr. Parada, thank you for your patience. I would just like to go back over some of the subject areas that Mr. Posner asked you about. But before I do that, let me just ask, how old are you, Mr. Parada?
51 years old.
And I think you testified you graduated from law school at what year?
2001.
So how old were you when you graduated from law school?
41.
Okay. Now, let's go back to your witness statement, and in particular, I'd like you to look back at paragraphs 6 and 7, where you talk about these two meetings in November and December of 2007 with Crowell and Mooring attorneys. Are you looking at those paragraphs, please?
Yes, I am.
Now, Mr. Posner asked, well, let me back up. Did you put in your witness statement your best recollection of what happened during the times that you reference in that witness statement?
What do you mean by my best recollection?
Well, did you put your best recollection at the time based on what you remembered and any documents that you reviewed?
No, I do not.
Okay, why not?
Because there was one particular, well, actually, there were several things I didn't put in. Some were not relevant. The one that was relevant, which was what Mr. Ali told me at the meeting in La Salle's, I did not put it in.
No, perhaps you misunderstood my question. I don't want to talk about at this point, we may get there, what you did not put in. Let me just focus on what you did put in, okay? With respect to what you did put in your witness statement, was it your best recollection based upon what you remembered and the documents that you reviewed?
Yes, what is there is my best recollection.
Okay. Now, Mr. Posner asked you a series of questions about whether it was possible that Mr. Ali was not at the first meeting on November 27th at Crowell and Mooring. Do you remember those questions?
Correct.
Okay. Let me ask you this. Is there any doubt in your mind that you met with attorneys of Crowell and Mooring on November 27th, 2007 at their offices?
No, there's not.
And let me show you what you have attached to your witness statement as S10. Can you identify this document for the record?
It is an email dated December 4th, 2007 from Mr. Alex de Gramont to me, in which it says, "Dear Luis, I enjoyed seeing you recently. Here is the exit in the Americas article that I mentioned to you."
And you see Mr. de Gramont says, "I enjoyed seeing you recently."
Correct.
This is on December 4th, 2007, correct?
Correct.
And this is between those two meetings in time?
Yes.
Now, when Mr. de Gramont says, "I enjoyed seeing you recently," do you know what he was talking about?
It's talking about the meeting, the interview that we had the week before.
Okay. Now let me ask you about Mr. Ali. Is there any doubt in your mind that you met with Mr. Ali in at least one of those two meetings, November 27th or December 7th?
No, there's not.
Now, how do both of those dates, November 27, 2007 and December 7, 2007, relate to the nationalization of the claimant? Are they before or after?
Those both dates are before the date in which the claimant became a U.S. enterprise.
Now, let's go back to your witness statement, paragraph 7, because you have a specific comment about what Mr. Ali said. And I have reference to the last sentence of paragraph 7. Now, this paragraph is about the December 7th breakfast meeting, correct?
Correct.
And in the last sentence, you say, Mr. Ali also mentioned that he had been present at a meeting with President Saka during President Saka's official visit to Washington, D.C. 1 week earlier. Do you see that?
Yes.
Had you heard from any other source the suggestion that Mr. Ali had had a meeting with President Saka during that visit?
No.
Okay. Do you know whether in this arbitration the claimant has ultimately admitted that Mr. Ali was at that function during that week?
The claimant finally admitted in one letter that Mr. Ali, among others, was present at a function during President Saka's visit to Washington the week before our breakfast meeting.
All right, let's put in front of you claimant's April 22nd letter. And for the record, the tribunal will find this attached to our April 27th letter to the tribunal. And I have highlighted a section of that letter. Can you read the highlighted sentence into the record?
Yes, it says, on 28 November 2007, Messrs. RFH Ali and R. Timothy McCrum attended a large ticketed luncheon in Washington, D.C., which was sponsored by the International Republican Institute, in parentheses IRI, and where then President Saka was the keynote speaker.
Okay, and I think you have in your, I'm going to stand up so that the person in the booth knows that the mic can be turned on. I'm going to put on the board a 2007 calendar, which I think you should also have in front of you. And I just want to mark these dates. Tell me again when your breakfast meeting was with Mr. Ali and Mr. DeGramont.
On Friday, December 7th.
Okay. I'm going to write, I'm just going to put a B there for breakfast because it's a small box. And let's look back at your witness statement. Just, can you pull that off the board without destroying the B? If not, I'll put it back. Let's just look at your witness statement again. And you say in paragraph 7, Mr. Ali mentioned he had been present at a meeting with President Saka 1 week earlier.
Correct.
Okay. Put the calendar up again now. So here's the breakfast on December 7th. 1 week earlier, we're talking about which week?
We're talking about the last week in November.
The week of November 25th, correct?
Correct.
And in fact, in the letter that the claimant submitted to the tribunal, when did they say that Mr. Ali attended this function with President Saka?
They said it was in November, on November 28th.
During the week that you had reference to in your witness statement, correct?
Correct.
And again, did anyone other than Mr. Ali tell you that he had attended that meeting?
No.
Now, let's look at Annex D again, which I believe you testified was an email that you sent to the Attorney General on March 7th, correct?
Well, that email itself is addressed to the administrative assistant to the Attorney General.
I stand corrected, thank you. And what is the date of this?
Date is March 7th, 2008.
And was this before or after the article attributing various comments to President Saka about an alleged mining ban?
This was before the article.
Okay. Now, do you remember Mr. Posner asked you a series of questions suggesting that the phrase possible international dispute in your email was a reference not to the dispute that we are now here talking about today, but to another dispute called the Commerce Group dispute? Do you remember those questions?
Yes.
Did you have any role in the Commerce Group arbitration?
Yes.
What was your role?
Counsel for El Salvador.
And who was the other party in that arbitration? I take it was the Commerce Group?
Yes.
Who was counsel for the Commerce Group?
Counsel for Commerce Group was a family-related law firm, Machulak, Robertson, and Sotos.
I'm sorry, can you say that again for the court reporter?
Or Maculak, spelled M-A-C-H-U-L-A-K, Robertson, and Sotos. And they also had, also as counsel, Mr. Andrew Newcomb.
Were you involved at all phases of the Commerce Group arbitration?
Yes.
Who was the Attorney General of El Salvador when Dewey was hired to represent them in the Commerce Group?
He was the current Attorney General, Mr. Romeo Benjamin Barahona.
Okay. And who was the Attorney General when Dewey was hired to represent El Salvador in this arbitration?
He was the previous Attorney General, Felix Carrizafi.
Okay. Now, in your role in the Commerce Group arbitration, I take it you had access to the filings that the parties made to the tribunal?
Yes.
Did you ever see in the entire course of that arbitration Kroll and Mooring appear on behalf of any party in the Commerce Group?
No.
Did you ever hear from any source that Kroll and Mooring ever did any work at all for anybody in connection with the Commerce Group arbitration?
No.
Now, you were asked a direct question. Was it possible that this dispute that you were talking about was really the Commerce Group arbitration and that you misunderstood or misinterpreted what you heard from Messrs. de Gramont and Ali? Do you remember being asked that question?
Yes.
And I believe your answer was it was not possible.
Correct.
Why was it not possible that the reference was to the Commerce Group arbitration?
Because the description of the dispute in both cases is entirely different and inconsistent with each other. It could not have been the Commerce Group dispute because Commerce Group was alleging expropriation based on the rejection or termination of the revocation of the environmental permits that they already had, and they already had a exploitation concession. Pacific Rim, on the contrary, was merely applying for the environmental permits and applying for the exploitation concession. So they could not have been asking the government to approve those permits because those permits had already been, Commerce Group could not have been asking the government of El Salvador to approve those permits because those permits had already been approved. Their dispute would have been trying to get the revocation removed.
So based on your discussions with Mr. Ali and Mr. de Gramont, was it your understanding that the dispute was about obtaining permits or revoking existing permits?
It was about obtaining the permit.
You were also shown a series of emails where you talked about how you had learned of the dispute a few months ago or a couple of months ago. Do you remember those emails?
Yes.
And I think they were dated in the spring sometime of 2008. Do you remember that?
Yes.
Okay. At the time you wrote those emails, when you used the term a couple of months ago or a few months ago, did you have any belief when you were composing those emails that you needed to be precise as to when you actually learned of the date that the dispute arose?
No.
In fact, when did you first learn that that was an issue at all in this arbitration?
After El Salvador filed the objections to jurisdiction.
Yeah. And there was one email in that sequence about when you learned of the dispute that Mr. Posner did not put in front of you, and I'd like to put in front of you again, and that's Annex R.
Correct.
Now, you sent this email on December 10th, 2008. Is that correct?
Yes. Yes.
And tell me again the circumstances of you sending this email.
This email was in response to a previous email from Mr. Eric Schwartz, partner at Dewey and LaBeouf in the Paris office, who had sent the email to the recipients of my reply, including and to myself, alerting us that there had been a notice of arbitration filed against El Salvador. Then I replied to him and said, thanked him, and I don't know if you would like to read what I said. Or
Sure, can you read the highlighted sentence, please?
Okay, well, it says, we have been on top of that dispute since last December when I first learned that opposing counsel was preparing for arbitration.
And by December, you have reference to December of 2007?
Yes,
And by opposing counsel, do you have reference to the gentleman sitting at claimant's table there?
yes.
No further questions on redirect.
Thank you very much. Are there any further cross-examination questions?
I do have a handful of questions. I expect no more than 5 minutes worth of questions, if I can just have a moment to confer with my counsel.
Of course you can.
Mr. President, as I said, just a handful of questions, if I might. I'd like to start, Mr. Prada, with the last exhibit, or I guess document that Mr. Badini had you look at. This is Annex R to your witness statement. Do you have that in front of you? This is your email to Mr. Schwartz.
Yes.
And what's the date on this email, Mr. Prada?
December 10th, 2008.
And in fact, this is after PACRIM came and had filed its notice of intent in this case, isn't that right?
Correct.
Now, Mr. Badini asked you a series of questions about the Commerce Group case. Did you know back in the fall of 2007, that is in November and December 2007, who would be representing Commerce Group in that arbitration?
No.
Did you know anything about the Commerce Group dispute back then?
I don't believe so.
So you didn't know at that time that that case involved a revocation of permits, whereas this case involves a failure to grant permits, correct?
No, at the time I did not know it.
And you didn't know that when you sent your March 2008 email to the Attorney General, did you?
No.
One last question, Mr. Prada. If we could go back to, I think it was Exhibit S, as in Samuel 10. This is the December 4th, 2007 email from Mr. DeGramont to you. Do you see that?
Yes.
And Mr. DeGramont attaches to that email an article from Global Arbitration Review, correct?
Correct.
And that article was co-authored by Mr. DeGramont and Mr. Ali, correct?
Yes.
Wouldn't it, and presumably, well, do you know why Mr. DeGramont was sending you the email with this article?
He mentioned it during our conversation.
And wouldn't it have made sense if Mr. Ali was also part of that conversation for Mr. DeGramont to have copied Mr. Ali on this email?
Objection, competence.
I'm sorry, could you repeat the question?
I'm simply asking.
It's not a question for this witness. It's a fair comment to the tribunal as a submission, but not for this witness.
Okay, I'll withdraw the question then, and I have nothing further.
Further questions from the claimant?
I have nothing further, Mr. President. Sorry. Your Honorable President.
Usually it's members of the jury, but we'll take anything we can get. Well, thank you very much indeed for your patience this morning. We've now come to the end of your testimony. The tribunal has no further questions.
Thank you, sir.
So we'll adjourn now, and we'll resume at 1:30 for the next witness. Thank you.